I'm just going to call this meeting today. It looks like we got some folks jumping in here. So welcome everybody. This is going to be a webinar on the upcoming legal challenge. I don't know if you've seen TheraPsil's website, but there is a challenge that is likely going to be brewing in the next couple of months here. So we've brought a number of patients and lawyers onto this call to discuss why they might be seeking access to psilocybin and why court might be the only option. So thank you everyone for joining. It would be great if we could just get everyone to maybe say where you're from, just joining from in the chat. So you'll notice on the bottom, there are a couple different functions. The first is the chat function. So that's where you might just say where you're from. Feel free to cheer people on and ask some questions or make comments in there. But otherwise, if you have any questions throughout the webinar, the Q&A is the best place to put those. That way we can make sure we get to them. We're not always the best with timing and getting to all of them, but at least we don't lose them. So we'll do our best today to get through everyone's questions. If you get them at any point, feel free to either throw them in the chat or if you don't want them to get lost in the Q&A. All right, before we get started here, I just want to respectfully acknowledge that today we're conducting this webinar on the traditional and ancestral territory of the Musqueam, Squamish, and Tsleil-Waututh Nations. I also just want to acknowledge that psilocybin and many of the other substances that we're working with nowadays in the more medical and Western context likely exist and are here because of thousands of years of knowledge transfer and use by Indigenous and First Peoples across the world. So I want to just pay my respects and say thank you for passing on such wisdom and passing the gratitude of having this knowledge. So I guess without further ado, we'll just get started with some introductions. I'm Spencer Hawkswell. I'm a patient rights advocate and CEO at TheraPsil. And I will just pass it along here to our speakers to introduce themselves. And Thomas, you're next on my screen, so I'll start with you.
Hi, everybody. I'm Thomas Hartle. I'm a stage 4 cancer patient from Saskatoon, Saskatchewan. I will pass over to Paul, who's next on my list.
Thank you, Thomas. Paul Lewin. I'm a longtime cannabis lawyer in Toronto and a psychedelics lawyer, and I've got a lot of experience in constitutional law.
Awesome. And Laurie, it looks like you're next.
I'm Laurie Brooks. I am also a cancer patient. I've been living with cancer for 4 years and one of the first 4 to be granted access to psilocybin 2 years ago.
Thank you, Laurie. And Jim, over to you.
Oh, hi. My name's Jim Doswell. I'm a patient of TheraPsil, but I'm also on the board of directors. I did not have palliative issue. I had cancer in remission in 2 forms, but anxiety and depression and trauma was the biggest reason that I wanted to be treated. So thank you.
Thank you very much, Jim. And David, over to you.
Hello, my name's David Wood. I'm a lawyer and patent agent, and I focus on psychedelics, cannabis, regulatory, and intellectual property law. And I split my time between an in-house position at Cygen Industries, which is a manufacturer of psychedelics, and my own legal practice.
Wonderful. Thank you very much, David. All right, and I just want to say thank you to all of you for joining this call and helping with one of the most important things we do is advocacy and education. So really looking forward to this webinar. I've got a couple of questions that were sent in prior from a number of people responding to the initial message about this webinar happening. And again, if at any point anyone has any questions, please feel free to pop them into the Q&A. I'll do my best to monitor that. There's no interrupting, so pop it in, and if it comes up and is the right time to answer, we'll get to it. So without further ado, I think the most appropriate thing to do is to put it out to Thomas, Laurie, and Jim. Thomas, maybe I'll start with you. What's the purpose of going to court? Why do you think now is the time to seek a constitutional challenge?
Well, I think we all sort of have our own reasons for that. My personal reasons are I have been one of the first 4 people like Laurie who received access to psilocybin therapy through a Section 56 in 2020, and that has since expired. I have found the process of trying to get access to this treatment, which has been so very successful in treating my end of life anxiety, to be an extremely difficult process. And in my opinion, this is a type of treatment that really should be available to everybody who needs it. And until somebody actually takes the steps to really make this issue something that's in the forefront, not only of in Canadians' thoughts and the politicians, I believe that we won't be able to really move forward in getting this to be a valid legal therapy that other people will be able to have access to. So I'm trying to be, the point of the spear for my own personal reasons, and hopefully that other people can benefit as well. I think you're still muted there.
Thank you. And thank you very much, Thomas. Jim, I'll put it over to you.
Oh,
Same
okay.
question.
I think my reasons may be a little different, but they're just because my experience is different. I know it works because it worked for me. I don't know if it's going to work for everyone. I sure hope it would, but it won't. I have no anxiety anymore. I may be a carrier, but I do not have anxiety. And furthermore, the traumas in my life, which have been interesting in many and probably would be a great script for a bad B movie, aren't traumas anymore. They're dealt with. So when I went into this, I had that attitude, but I also had the attitude is that I don't need the Minister of Health to give me permission to use mushrooms. I don't give a rat's ass if he thinks I should use mushrooms, or if he thinks he needs to give me a letter to do so. I do have a Section 56, which criminalizes me if I follow the terms of it. I care about the people who give the treatment. And from the very beginning, I thought it was incredibly unfair in a country that people providing compassionate care could be criminalized by their behavior just because of the substance I was using. So I think more than anything, that's what I think our government needs. And also, having been a deputy minister in my life in Canada, I know that our government loves to have court decisions to prompt moral behavior. And we don't seem to have the courage politically in our country to do things, no matter what they are. Social change is hard for us without direction from the court. So our court tends to give very good direction to our politicians from time to time. And I'm hoping that's what we accomplish. Thanks, Spence.
Thank you very much, Jim. And Laurie, I'd like to put it over to you for your personal interests and the reason why you're going to court.
Sure. Thanks, Spencer. For me, yeah, what Thomas and Jim just said is exactly true. I did my first mushroom trip underground with a therapist who was a friend, and it made a huge difference for me in going through cancer the second time. It took away all the anxiety, helped me work through my grief and trauma, and that was 3 years ago, more than 3 years, 2.5 years ago, however long it was. It's still working now, and I just think I'm just so passionate about getting this medicine for other people that are suffering like I was. And the court case, if that's what we have to do, then I guess that's what we have to do, because it's just not right that the government is not allowing people to use this drug or plant medicine, whatever you want to call it. It's just not right that we don't have access to it when we're suffering.
Thank you very much, Laurie. And I feel like the context too that I certainly understand here is that this is 2 years of you and Thomas advocating for access to this. And even Jim, in your case, I believe there was quite a bit of legal battling that was going on last December in order to get you and a couple other people access. So, you know, I understand that it has been a long battle, and this is definitely not the first choice. Paul, you've been working and advising TheraPsil, and back in 2020, we're supporting both Thomas and Laurie in what was going to be a similar challenge, except the Minister of Health granted the exemptions. You've been a huge supporter of this for a while, and I'd love to hear your thoughts on a constitutional challenge on court, why it may be necessary, what our standing is, and why you believe it'll succeed.
Well, the test, and a lot of people look at various psychedelics. They say, well, you have to get a drug identification number, and you have to do all the research and do all the studies. But that's not how our Charter of Rights and Freedoms views it, and that's not how our courts view it. The test, if you're before a judge under Section 7 of the Charter, is whether or not you should be permitted reasonable access to the drug. That's what the government has to permit. They can't put obstacles in your way that do not permit reasonable access. Is it reasonable for someone facing severe anxiety or depression because of perhaps a life-threatening health condition? Is it reasonable for them to be able to access this drug, which actually has a great safety profile, is very low toxicity, has a tremendous record of medicinal benefits? I think that it's very clear. This really is a no-brainer. And really, the real question is, how are these exemption schemes, which are flawed and problematic in many different ways? But the shorter answer is, it's a very strong argument. And I think people are looking at it the wrong way. And the real question, as I've said in the past, is if you come to a bridge and maybe under normal circumstances, you might ask some questions about how safe it is to cross this bridge. But if you're being chased by a bear, you run over that bridge. And so the question, and that's really what these patients are facing. They're being chased by a bear, so let them run over the bridge. Thank you.
I like that analogy. And I also see that Janis has joined the meeting here. Janis, I want to just give you an opportunity to introduce yourself. So you could run in a couple minutes late, but no problem. We've just done a couple introductions and gone around and spoken about why you're interested in a court case and why you see it as necessary at this point. So just want to put it over to you and give you an opportunity to introduce yourself.
Okay, I'm a stage 4 breast cancer patient. This is my 3rd go around with cancer. When I got my diagnosis, I was struck with panic. And really, I only settled down when I discovered that there was this option of psilocybin that promised to relieve my end-of-life anxiety. And I've made it a kind of single-minded pursuit ever since, but it's kind of dragging now. I started this process back in October, and I'm getting impatient. I tried to, I'm in Manitoba. There are no clinical trials available here, and there are no doctors that seem inclined, well, that I've been able to identify as of yet, that are inclined to undertake the SAP process. I asked my 3 care providers, they all turned me down. I think it's going to take time to develop a repertoire here in Manitoba. I don't feel I should be disadvantaged because of my geographical location in terms of accessing psilocybin-assisted psychotherapy. I shouldn't have to travel to the West Coast where it seems to be a little more accessible than it is here. And speaking to Paul's point, it's like I've been asking myself today, why does the government not have to justify branding something a dangerous substance? I mean, just the evidence is not there for psilocybin, as far as I'm concerned. I mean, I'm learning about all of the dangers of sugar. It's an addictive substance, hugely harmful to individuals and society as a whole. It is totally unregulated. And I'm going, like, psilocybin is a controlled substance and sugar is not. Like, where's the logic? So I abhor illogic. I'm in this fight because I see this legislation as being total. I don't know if they're following in the US footsteps, but it's totally unjustified to class psilocybin along with other more harmful substances, as far as I'm concerned. I'm in this fight in part for my friends who suffer from debilitating anxiety, who are not facing end of life distress as I am. I am reasonably, I mean, I'm bound and determined to pursue this, whether legal or not, but I'm in this fight in part for my friends who have debilitating anxiety, whom I feel this treatment could be life-changing for them. I just want to see legalization. This is a step along that road.
Well, thank you very much, Janis. And I think it really is good to acknowledge that, you know, the four of you are here to support and speak for many other, you know, people who are looking for access to psilocybin who can't be here tonight on the webinar. Some of them, unfortunately, have passed away in the last couple of years, and many others are unable to, you know, get up here and speak and maybe have the courage, or have the time, or even just the understanding of what it takes to get up on the stand and really expose your life to the Canadian people and politicians. It's certainly not easy. So I just want to applaud all of you and thank you for you know, the support that you give to all the hundreds of other patients that are looking for this access, and the thousands of people who at least have contacted TheraPsil looking for support. Something I keep hearing and over and over again from each person is that they're doing this for multiple reasons, and that they want to see something come out of this, a solution, some form of fix to what is right now a pretty crummy regulatory process, either Section 56, SAP, or clinical trials. So David or Paul, I'm going to put it over to one of you. What might be the solution here? What might the courts fix so that people don't need to go to court anymore? What's a potential solution? What have we seen with cannabis that might apply to psilocybin, for example?
Well, I'll start, and I know David has lots of thoughts on this as well. So the court only does strike down. The court won't create a regime, but what the court will do, and how cannabis played out, is they struck down before there was a medicinal regime for cannabis, and they said, hey, why don't you apply for a Section 56 exemption at a time in which they'd never granted one before. And the courts struck it down. They said this opaque, discretionary decision-making, the system of like bureaucrat as gatekeeper, was struck down. The government was given a year to fix it. And, you know, and the fix that they came up with was the MMAR. And I think David and I both agree that's a good idea. I'll pass it over to David and on that note.
Yeah, thank you. And I agree. So right now, one can get permission to possess and use psilocybin through a subsection 56(1) exemption, but that doesn't give one the ability to source it from anywhere. And as Jim pointed out, I actually disagree with what Jim said. I don't think he becomes a criminal by receiving psilocybin under that exemption, but he is, and I don't like the word criminal, but he would have to interface with someone who is contravening the Controlled Drugs and Substances Act, or he'd have to walk out into the forest and find these mushrooms wild, which has its own challenges. He can't buy them from anybody in compliance with the law, where the vendor is in compliance with the law, and he can't grow them himself, at least if the exemption looks the way I think it does. So that's not a great system. And then, as Paul mentioned, there's the special access program, but that's only available for emergency use. And like a clinical trial, you may not meet the criteria of emergency use. So while that can be attractive if you fit the criteria, because then you can source psilocybin from a regulated source, its application is narrow and there's a big administrative burden on the doctor. So, and this kind of speaks to one of the questions in the question list. Someone asked, what would psilocybin legalization look like? And I'm sorry if I appear a bit focused on words, but I also don't like the word legalization. I think, it's not really illegal. It just happens to be a controlled substance. But I think that it could look a lot like the ACMPR did, which was Gen 3 of the Pre-Cannabis Act medical access regulations under the Controlled Drugs and Substances Act. Like, I don't know why we'd reinvent the wheel. And that's why TheraPsil's proposed regulations look a lot like Part 14 of the current cannabis regulations, but they're under the Controlled Drugs and Substances Act, much like the ACMPR, which would mean you'd have products, and I'll do this thing that I do a lot on these. I'll hold this thing up. This is a cannabis product. This doesn't say these pre-rolls will help you with your headaches or your arthritis or help you sleep. Doesn't say that at all. Just says, be careful, this is dangerous right here. And then right here, it says how much THC is in it. If this is going to be used medically, and it can, then it's up to the doctor and the patient to sort of figure it out themselves based on what the patient's comfortable with. We could do the same thing here. And to me, that approach would get a large number of Canadians regulated, quality control products that their doctor believes they should have, regardless of the absence of a DIN, drug identification number. And that would probably make it happen the soonest and in larger, more accessible numbers. And I mean, this is a creative approach to healthcare because, again, doctors aren't used to products that don't have indications listed on them. But I mean, we've had success using cannabis medically this way in Canada, and we've all seen creative approaches to healthcare, and certainly corners being cut on widely applied therapeutics in the last 2 years. I don't think it's a huge stretch to say a medical access system for psilocybin makes sense. And last point, always, medical access is not pharmaceuticals. Pharmaceuticals have an indication and they have product specific approvals. Like when you go buy ibuprofen that's formulated at a certain dosage in a certain capsule, it's the same no matter who makes it. Cannabis products aren't like that. And psilocybin products, as I imagine them, wouldn't be like that, but that doesn't mean they can't be used medically. So never conflate a pharmaceutical drug product regulated under the Food and Drug Regulations with a cannabis product regulated under the cannabis regulations. We're envisioning a similar psilocybin product regulated under a new set of regulations that Spencer linked our proposed version of to in the comments. Thank you.
Wonderful. Thank you very much, David. And just a quick follow-up question on that. Would you say that the difference in medical versus medical regulations or medical access and something with a DIN per se, would you say that that difference is there because you can grow psilocybin, because you can grow cannabis and it is natural?
I think that the reason we got medical cannabis, and I think the same holds true for psilocybin, is that, as you pointed out, it's a material that you can just grow. And then also it's a very safe material. I mean, there's plenty of evidence to back that thing I just said. I'm not going out on a limb there. At least toxicologically, there are certainly severe consequences that can result from using psilocybin, especially at high doses in the wrong setting. But none of its dangers are dangers that cannot be accounted for by responsible use. The substance itself is not toxic, not really. So that's another reason I think we had cannabis get turned into a medical product that had no DIN. And there are Sativex has a DIN and has THC in it, but it's not used a lot in Canada. But it does have a DIN, and it is available in at least one province. But so nothing precludes a pharmaceutical with psilocybin from being brought to market, even if our system like what we're proposing were to exist. So I think, and then the third thing is that it's efficacious. So we have drugs that are safe, that are efficacious, and that are easy to make just by growing a plant and drying them, or a fungus, and drying material from that plant or fungus. I think, and the MMAR that Paul mentioned, that was generation 1 of 4 really of our medical access regulations. And it was almost completely reliant on personal cultivation. You could buy cannabis from one government source, but you could, most people, on my understanding, who access the MMAR grew it themselves. On Gen 4, which is the cannabis regulations, you can grow or you can purchase products like the one I keep holding up. And I think that would make the most sense here. And if there were any sense for caution on the government's part, maybe just keep it to only selling the products, because then there's always quality control. But I think, most people who've grown any kind of mushroom know it really is not that challenging. And the challenge would be making sure none of the material is diverted away from the person who's supposed to use it. And it might depend on the use case. If someone has cluster headaches and they're eating grams of these a day, that's different than if someone needs 3 breakthrough experiences in a year and no more ever, right? The latter might make a lot more sense to just purchase the products rather than to cultivate, because one's sort of flush and you're going to have way more than you need for 3 breakthrough experiences.
Wonderful. Thank you very much for that explanation, and good points in bringing in patients that might have, for example, cluster headaches. There's a large group of patients that we've supported who have cluster headaches and are looking for access. And they are sometimes a silent voice, but thank you for bringing that to attention, as there are many people who use this quite frequently, sometimes up to once or twice a week, 1 or 2 grams. And there are limitations to the existing regulatory pathways, such as Section 56 and SAP. Specifically within SAP is the lack of patient possession. So I think that what I want to do here is highlight, again, part of the reason that we're going to court, that the patients are going to court, is that there are limitations to the current regulations. I want to put this over to specifically Janis and Thomas, and maybe Thomas, I'll just start off with you. Would you like to explain some of the limitations that you've seen as you've explored the regulatory pathways, and maybe highlight what they are and what the big problems were for you?
Sure. Now, are we looking at the differences between SAP access and the Section 56 access that I've had?
Yeah, sure. I think it might make sense to explain them both as well.
Sure.
For those out there who might not understand.
With the Section 56, the procurement, the storage, the security of the psilocybin itself is on the patient side. So with my Section 56, in particular, I did grow my own mushrooms because, of course, as has been mentioned, there isn't a legal source that I could just safely go and buy from. So because I'm treating end-of-life distress, I wasn't interested in having to then look for a gray market source or a questionable source of the psilocybin. I guess you could probably term that. The advantages to that is it gives me a little more freedom for my therapist and who I have to sit with me during a psilocybin session. So in my particular instance, I did the majority of my therapy through Zoom calls with my therapist. And I have options to have a medical practitioner present, which is a requirement of the Section 56, but it does not specify that that person has to be a medical doctor per se. With the SAP access, it sort of flips the responsibility from the patient to the physician. So as I understand it, the physician then becomes responsible for filling out about 8 pages worth of paperwork. They are responsible for procuring the psilocybin, for storing the psilocybin, for the administration of the treatment, and for reporting back to Health Canada the results of that treatment. So it limits the patient's ability to, select a therapist that needs to be a trained physician. And unfortunately, there are a fairly limited number of those currently available. So not only physicians who are qualified to work with the psilocybin-assisted therapy, but who are familiar with it enough to feel comfortable to actually process a Section 56. It becomes very difficult. I myself, for SAP access, had to travel to British Columbia because I have not been able to find a physician here in Saskatchewan who has an interest in doing the Section 56 application for me. So like Janis is experiencing difficulty finding somebody, my family doctor, my oncologists, not really their area of expertise. So I can't really blame them for not being so enthusiastic about that. There are specific doctors who are qualified and interested. I just have not found one here in Saskatchewan yet. I think you are still muted.
I am
again.
still muted. Thank you very much. Thanks for sharing that, Thomas. And Janis, I wanted to put it over to you too, as I realized that this has been a special challenge for you as well, and explaining that sometimes to the decision makers. So want to put it to you to maybe talk about some of the real challenges that you've had with the SAP.
Well, yeah, part of the challenge has just been the confusion at Health Canada's end. It seems like they've been changing the rules midstream. So when we first heard about the SAP, it seemed clear that the prescribing practitioner had to keep possession of the drug, and we're going, well, how does the psychotherapy fit in? Does that mean that the physician has to be present? As it turned out, I ended up getting a meeting with a senior advisor to Health Canada, and she explained that had changed. It was no longer a requirement. So it was like they're changing the rules midstream. It's all very confusing. My one provider had never heard of the use of psilocybin for this purpose, referred me to my GP. My GP filled out the original application, but made it clear she was inclined to end her participation there. My oncologist, by the time I saw her in person, I knew about the SAP process, and I told her that she had the right to apply to prescribe this to me, but she wasn't she was familiar vaguely with the SAP process. It wasn't something that she wanted to touch. And she vaguely referred to a set of doctors who are regularly prescribing methadone, I guess, who are using the SAP process to access methadone for their cancer patients. But she gave me no referral, and I'm going, well, what do they know about psilocybin? What would be, why could they know nothing about me. What would be their interest in helping me? I didn't pursue that. I just went to Natasha of TheraPsil, and I went back to my GP, and she was just totally disinclined. She didn't know where to start. Man, I felt very self-conscious asking her to do this. Also, my history with her is that she's been late with everything. And I wasn't inclined to wait for her to get around to this. So yeah, just really not And I was offered the opportunity to participate in the study or in the group therapy that Thomas took advantage of, but that just offended me that I should have to travel and incur that expense. Also, my whole understanding, I am pursuing psilocybin assisted psychotherapy, and I'm looking to achieve the best possible experience. It seemed to me that travel in COVID times, just even travel at the best of times, introduces uncertainty. You're in an unfamiliar environment. None of that seemed to me to be conducive to the best possible megadose experience, you know, with its potential for suggestibility and influenceability by paranoia. And yeah, just whatever's on your mind. Why introduce all of it, these variables that could inhibit a good experience? I just thought that was counterintuitive. So yeah, I turned down that opportunity. And the fact is, in Manitoba, there are therapists available. They're working underground. Part of the major part of the utility of a Section 56 exemption for me were to bring these therapists out of the shadows. It's once I have approval, they're legally protected, or that's how they perceive it. And that's really the only way to access the therapy here in Manitoba. So that's why I went that route, because I didn't want to just take the drug on my own. I wanted to take it in a controlled environment that was safe and supervised. And that's what I'm pursuing. I guess my other objection that I brought up in the previous webinar to the SAP process is that it seems to favor these companies that are manufacturing the drug, doing clinical trials, and also offering psychotherapy. They're going to be well set up to generate these applications using the special access program for patients. But if you're going to use them for that, you're going to be obliged to take their drug and use their therapy. And what if it doesn't? What if their modality for therapy isn't aligned with what you want?
I could speak to that briefly if you like, actually.
Sure.
If there's a company that A, operates clinics, and B, also makes psilocybin products, then I don't think they'd have any. I think the physician practicing medicine at that clinic, who's a professional with ethical obligations, would probably be remiss ethically to require that you ask for the products from that particular company. There are not very many companies at all that are able to provide psilocybin through the SAP right now. And I think if you're working with a physician who understands what's going on here, and there's definitely some, I mean, I'm aware of several. I don't know how many I'm aware of that have been issued now, but several, like still less than 10 that I'm directly aware of. Counting Thomas's as one, even though there were 6 people involved with that one. But in terms of events that are approval events, I'm aware of a few of them. They've been fulfilled by a small number of companies, and 3 different companies that I'm aware of. So I think that concern might be an easy one to address, but also at the end of the day, because the standards, as you correctly pointed out, for what Health Canada is going to say yes to under the SAP line up pretty closely with what they'll say yes to for a clinical trial, you are probably looking at either highly purified psilocybin that was from cultivated mushrooms or synthetic psilocybin. That's probably what you're looking at today. Health Canada on Friday, 6 days ago, released a statement clarifying that for both clinical trials and special access program requests, anyone who wants to work with fruiting bodies of mushrooms, they'll have to be homogenized and made at GMP standards, and all these things that will, not in an intentional way, not in like a legislated way, but in a practical way, will mean there are more things that have to get done and more work that has to go in and more money that has to be spent to bring a capsule to you that has ground up fruiting bodies in it compared with a capsule that's just pure psilocybin plus excipient. So that is a perceived drawback of this system, but whether it's actually a drawback would depend on the situation. Because I know there are people that very strongly believe that mushroom is in some way better than synthetic psilocybin. Whether or not that's clinically proven to be true, I think with something like this, where we're talking about psychotherapy, we're not talking about shrinking tumors. We're not talking about killing bacterial infections or stopping the progression of a viral infection. We're talking about mental health. So to me, and I'm not a therapist, but I'd be interested to, talk to some about this. If a patient really believes that a mushroom that comes from the earth, et cetera, whatever their belief structure around that is, if they really believe that that's going to give them a better outcome than a synthetic product, or conversely, if a patient maybe is apprehensive about dosing and they have more confidence in a synthetic product compared with a naturally sourced one, that might affect outcome. And that's something that itself could be trialed. But I definitely hear you on the obstacles, and the system that TheraPsil's proposed would allow both, which to me is just the best, like give the physicians what they think will work for their patient, whether that's dried mushrooms that come in a can, much like cannabis flowers, or whether it's a synthetic pressed tablet or capsule with psilocybin and excipient in it. I think that we should kind of leave that decision up to the physician and their patient personally.
But how does Health Canada justify these onerous requirements? That's what I don't understand.
They're just applying the same requirements that apply to all drugs regulated under the Food and Drugs regulations. This is not regulated under the Food and Drug regulations. This is regulated under the cannabis regulations, and the requirements are different. So if the psilocybin regulations that TheraPsil proposed were brought into effect, if those were law, then the standards and all the money you'd have to spend to meet those standards would be more commensurate with this than with a pharmaceutical. I should have a box of Tylenol or something to hold up, but it's different, right? It's just a different system. And it's not, I would never blame Health Canada here. It's the law, like they're the regulator, they're going to apply the law, which is one reason why there's a challenge on the prohibition of psilocybin, right? Because we're hopeful that gets us to a point where something that looks like this, but is psilocybin, but is regulated in a similar way to this, could be manufactured commercially in compliance with the law, transferred to the patient in compliance with the law, or to their doctor for use on the patient. And then it's all simple and quality controlled, and you know how much is there.
And it sounds like that, what we're doing then is we are, and it has been our strategy since day one, is, we have not been necessarily asking, the law to change or even Health Canada, but we've been very focused on, the beginning it was Minister Hajdu, and I'm sure Thomas and Laurie remember putting together videos asking Minister Patty Hajdu to grant exemptions, and that's since changed to Minister Janis Hughes and Minister Carolyn Bennett, seeking their attention, because I think the point is that the laws that we have for regular substances do not work for psilocybin. They are failing patients, they're failing healthcare practitioners. And Janis, it sounds like from your experience and Thomas's experience, that both of you have been failed through the SAP. Even after getting SAP access, it still fails. And then there's Janis's unique challenge of seeking SAP access and seeing that, doctors who aren't working with an approved drug, well, they may ask questions such as, what's my liability, right? How much time is this going to take? Do I need to do all the reading? Is it responsible for me as a physician to grant or to request psilocybin for my patient, take on that responsibility, and then assign a agent or a therapist to then do the treatment? It's difficult. That's what's being challenged here is that maybe not it's the law's fault as much as the laws are just wrong. They don't work for psilocybin access, and they don't work for compassionate access. So I want to put just a question over to Jim, who commented earlier something quite wise, that very often we have to, bring a court case in order to force a political decision. And I do want to kind of comment on the fact that this is may very well be a political decision. Jim, do you want to just shed some light on that? Why you think that a court case is sometimes necessary in government to get things changing, and maybe your opinion on why the minister and why the politicians haven't stood up and, in my opinion, taken their responsibility to correct this issue?
Hey, Spencer, it's Holly. Jim had to step out.
Oh, oops. Okay. I will then push this over to Paul. Paul, in your experience dealing with cannabis legislation, and I know that this is something that we've talked with some of the other legal on our team. Is this something the government can still fix? Does it need to go to the Supreme Court? Does this need to be a 10-year challenge?
It does not need to be a 10-year challenge. It does not need to go to the Supreme Court of Canada. The Allard decision, which preserved cannabis personal growing rights, was a federal court trial level decision, which was never appealed even to the Federal Court of Appeal. Parker, the seminal decision on cannabis, the original cannabis decision that started it all, went to the Ontario Court of Appeal, didn't go any higher. So, I mean, the government will listen, and I think they are listening more. It's a little bit of a dialogue back and forth, and there's some conversation, and then there's some litigation, and they watch what's going on in the courts. And this isn't the late 90s. This isn't 1999. We've learned a lot in the last 20 plus years about the failures of the drug war. And so I think the governments we're dealing with today aren't the same as the ones then. And they've done some progressive things. So I'm not going to say it's all bad, but there's sort of a bit of both required. Some reasonable talking and some reasonable litigating, I think, is going to bring change. And no, we don't need to fight to the end of time to get results. We can even get results mid-case. They can say, you know what, you're making some good case points, and we don't need to go further. We're going to make some changes rather than have a bad loss in court.
And I'd add to that, when you're in dialogue with a regulator, it's so important. And I'm a patent agent as well as a lawyer. So I work with Industry Canada to get patents for my clients. And the mentality is, it translates to an extent. The person who's working for the government and who's a regulator, whether they're at Industry Canada for patents or at Health Canada for these exemptions or for licenses or whatever it is, they have a certain level of discretion, and there's a limit to that discretion. And it's important to know when there's progress to be made by discussing it with them and making a compelling case, but also to recognize when you can't just talk to them anymore and get further because they have their own mandate and there's a line they can't cross. That's where exploring court options makes sense, because as Paul pointed out, whether it goes to trial and concludes and there's an actual published decision, or whether it stops partway into the trial, which is better for everybody, as long as you get the result, the regulator's mandate might change and the limits of their discretion might change, which doesn't require a change in the law, doesn't require a public statement. It's something you don't even know when it happens, right? So knowing when dialogue without litigation will work is important, because that should always be the first choice. But recognizing when you're just wasting time and compromising the position of patients by not taking the step you have to take and bringing a court action, because again, there's a limit to how much discretion that person you're talking to is free to exercise. So it's important to know that the goal is not to have a fight. The goal is to accomplish a result, and that might include litigation. So something we have to look at as a broader strategy.
Yeah, thank you very much. And it's a good point, because we've had so many conversations, I think, with everyone on this call almost, and some level of Health Canada and or MPs who have, are part of that government. And you're right, they are wonderful people, and they've been incredibly respectful throughout this whole process. And I think that has been quite the challenge, is when you're in a room asking someone, why can't I access the psilocybin? And Janis, I will never forget the way that you put it one time. I think you said it feels quite patronizing, right? That someone might deny me access to psilocybin while acknowledging that medical assistance in dying is 3 days away. Yet they're making you wait 6 months, saying they're concerned for your safety or health. It's a logical inconsistency. It does not make sense. It's wrong. It's an injustice, and I think that's what this is realizing that it's not those people's belief. It really is the law that happens to be part of the institution that they work with. And so I think there is a great amount of sense in what we're doing here in this challenge and supporting it. I want to get on to question and answer because we've only got about 8 minutes left here. And within that, there, I think I want to make a quick time for one last question to Paul that was on our sheet. Court cases are not free. We've started fundraising for this case. We've recently got in about $25,000. We were aiming for about $100,000 to file and start off the case. And it looks like we have a donor who might be matching future donations up to $100,000, which is a fantastic bit of news. And it means that we may very well make it to this case. Paul, could you comment on just some of the costs associated with court? Maybe what it might take to file, but also what some other court cases have cost, such as Parker or Allard.
Yeah, well, Allard, I think it was around $1 million. And I mean, so there's several huge steps. There's putting together your record and a wide spectrum of affidavits, because that's the evidence you're going to rely upon. There's experts who are going to support all these different scientific points that you're making. They're going to file responses. You have cross-examinations in which you really have to prepare thoroughly for this. To do this right, we're going to have a large team of very skilled constitutional lawyers, a range of different types of lawyers. So yeah, I think like Allard, it could easily be $1 million. It's huge, but we're going to change the direction of medicinal psilocybin forever. So when you want to do something big, you got to go all in. There's no point in doing it halfway.
Wonderful. Thank you very much, Paul. I'll just put out a few questions here too. The first is Paul or David or anyone else in the room. Do you know if anyone's ever been arrested for buying and using psilocybin? And I'll actually put this. I'll put a little asterisk on it. Medical use of psilocybin, for any medical use of psilocybin.
Well, I can tell you because I'm representing some. So for sure, people are being arrested for psilocybin. They're not making fine distinctions between medical or non-medical use. I will note that it does vary a lot across the country. So it's going to be very different if you're in BC as opposed to Alberta or Quebec. The city of Toronto is very different than rural Ontario. But no, they'll just look at how much you have and take it from there. They're not making careful assessment of whether it's medicinal or not. Okay.
And then someone's just asked this question here, and maybe I'll put it over to Laurie here. What's the purpose of applying for Section 56? I guess as patients, why do you believe that that this should be done correctly, right, through legal channels? Why do you think there's merit to that, opposed to, I assume what this person was referring to is just doing it? Oh, and you're muted, Laurie. Oh, are you unable to unmute yourself?
There we go.
Oh,
Okay.
there we go.
Sorry, I've been having trouble with my audio. Why? Well, first of all, I think I was lucky because I am good friends with the therapist who took me through my first psilocybin experience. And it made such a huge, profound difference for me. I thought this needs to be available to other people going through what I'm going through, because I 100% believe that the reason I'm still here 2.5 years later is because of my psilocybin experience and being able to push the walls back when they were slowly moving in, then give myself that room to breathe and to go through the cancer treatments and make decisions, and yeah, knowing that the decisions I'm making are the right ones for me, and the psilocybin just helped me with all of that. Also, I think it's wrong that my friend was in danger of losing his license as a therapist for helping me. That's not right. So that was my other motivation. And then, last summer I had to step away and take a break from all of this. And then I saw Janis's story on the news and frankly was just pissed off because it's just not right what they did to you and other patients. And so then that's when I started getting involved with TheraPsil again, because I'm willing to fight longer because other people need to have access. And the onus should not be on the cancer patient who's so sick that I could barely get up and walk to the bathroom, never mind write a letter to the health minister. That's just not right. And I hope for the day where I can go and pick up my cancer meds at the cancer pharmacy and pick up psilocybin too. That's my dream.
Amen.
So glad you said that, Laurie, because the point I want to stress to Paul and David is that it's not just liberty, it's life and liberty. It's like life, it's potentially life extending.
And I also wanted to make the point that I don't want to die. And it's offensive to me to think that I could apply for MAID and be dead in a week. But I think my life has more value. And I still have things to add to the world. So,
I'm a firm supporter of this idea of medical assistance for suffering as opposed to medical assistance in dying.
Amen
The
to
MAID
that.
system, it's a necessary thing in my humble opinion. There is a purpose to it, but the purpose, of course, being to alleviate suffering, but it only has one mechanism for doing that. Why not eliminate suffering and allow you to enjoy the life you have left?
Freedom of choice over our own bodies.
What a concept.
I know.
Under assault everywhere. I'm pretty sure that you have sort of the same experience that I've had with the trying to get access to the SAP. Janis, we're dealing with, and Laurie, we're dealing with terminal illness. We're dealing with the treatment of that. We're dealing with the end of life anxiety. And the idea of also having to go door to door looking for a doctor to give you access to a controlled substance seems to be an icing on the cake that we don't really need.
Yeah.
Especially,
well said.
Yeah. And I just think its status as a controlled substance is highly debatable, in my opinion.
Yeah.
To that end, you might ask, has anyone on this call ever met anyone or heard wind of anyone who doesn't think that psilocybin should be available for someone with a terminal illness? And it's been 2 years, never even caught wind of that.
Mm-mm.
Nope.
So laws must change. I want to thank all of you so much for joining this call. We're at time now, but this is far from over. So really, really excited. This case is moving forward. We're going to continue to fight for all of you to get access to psilocybin through SAP Section 56, but hopefully through medical regulations. Something that's more fair, more accessible, more in line to not only your liberty, but your life as well, and your security of persons, all of it. So I just want to thank you all so much for this call, and I really look forward to the next couple calls that we're having and to continuing to advocate with you all. So thank you, and thank you to everyone who showed up as well. I think there's been a link thrown in for the fundraiser We are almost there. We're probably about 75% of the way there, with probably, I think, just a month to go. So we're really looking for donations. Please share it around. Anyone you know. It's the more small donations, the better. That's how this thing has been done in the past, and it's how we'll do it again. So thank you, everyone, and have a fantastic night.
Thanks.